Alrighty, let's go ahead and get started. I want to thank everyone here for attending our second Global Student Summit. It's really exciting to have everyone here. I think we're going to have a really wonderful presentation from Tanner Bean, and I'm excited to share this with all of you. And of course, all the people who will be watching the recording later on. We're so excited to have you guys with us in spirit. So I'm just going to go briefly over our agenda, and then we'll launch right in. So we'll start off with a prayer that will be offered by Taylor Crofts. She is a 3L at BYU Law and serves on the student board with me. I should introduce myself. I'm Jenna Crowther. I am the student board chair for this year. This is my last time as the student board chair. So back to the agenda. Taylor Crofts will offer a prayer, and then Amy Parker, who is the student chapters manager, will take us through the succession as we transfer chair from me to our incoming chair, Lucas. Really grateful for Lucas. And she will also give us a brief leadership training about chapter chair succession. Then we will hear from Amy Larson. She is the executive director of the society. She'll give us a brief message, and we are so excited to have her here. Then Lucas will give us the introduction for our speaker, who is Tanner Bean, and he will give us his keynote remarks. We will have a brief question and answer session, and Taylor will lead that. I will give some brief remarks at that point and invite Lucas to give a brief remark as well, and then Lucas will give us our closing prayer. So, Taylor, will you get us started with that prayer?
Yes, I will. Our dear Heavenly Father, we're grateful that we're able to meet here together virtually as students and attorneys of faith to be able to discuss how religious freedom works in today's society and the public sphere as times are changing and points of view and culture is changing. We're very grateful that we're going to be able to hear from Tanner Bean today, and we ask that thou wilt bless that we'll be able to learn from him and gain insights that will help us throughout the rest of our time as students and attorneys as we join into the larger society as a whole and balance our faith with the rest of the world. And we pray for these things in the name of Jesus Christ. Amen.
All right, Amy.
All right. First of all, this is cool. I didn't know that our website could even do this. I didn't know that we could have meetings like this, and it's awesome. It's just like Zoom. At this point, we just want to recognize an important leadership transition that's coming up. We want to thank Jenna Crowther for serving as our student board chair for the past year. She's done an amazing job in so many ways. She's had a vision that she's followed through with, including this Global Student Summit, and she's done a great job training me in my new position and teaching me all about student chapters. And as a token of our appreciation, we've got this award. If I put my face here, maybe you can see the words on it. We've got this award here for you that we would love you to swing by our office and pick up at any time. Jenna's at BYU Law. We're at BYU Law. So anytime, swing by our office and pick that up, and hopefully you can take it with you to your new office when you graduate next month, and just consider it a token of how much we appreciate what you've done for the student chapters in the Law Society. And we would also love to thank the rest of your board, many of whom are transitioning off. I don't know if anybody's sticking around, but we've got Taylor Crofts and Mason Cook and Victor Njoku and Warren Wood as our immediate past chair, who's long past his student chapter days, but has stuck around as a mentor and will be transitioning off as the immediate past chair. Jen will be sticking around as the new immediate past chair. And then welcoming Lucas Stevens as our new student board chair. He's been serving as the chair-elect and on the communication side of things for the student board. And he's graduating from Gonzaga next spring, so he will have a year to show us his vision, which includes, we're so grateful, so many skills with technology. Lucas is going to usher me at least into an age of like what we can accomplish globally with technology. So we're grateful for him and what he's going to do for student chapters. So with that, I don't know, is it normal? I don't know how to do this. Like, I'll give you a round of applause. Like if we were in an auditorium, that's what we would be doing. All right, thank you. And then I'll just go to my next part in the program. Does that sound right? Okay, just a really quick leadership training because it's that time of year that chapter chairs will be transitioning off as you graduate and new ones will be coming in, and just to keep everything cohesive so that the right communications are going to the right people, it's really, really important that you fill out the succession form on the website. And I'm just going to show you really briefly how to do that if I can share my screen. And choose what to share, the entire screen, but it's not letting me. It's blanking out my share button, Jenna, like it says that I can't click on it. Is that something that you can control?
It seems we have the screen, but we've lost your sound, Amy.
Interesting. Okay, there we go. So you can share a screen, but not a sound, and then you have to put you on mute, and then you come back. Easy to fix. All right, this is our website, and it's very easy to navigate. It's JRCLS.org. When you go to find the succession form, it's under chapters and committees right here. When you click on that, you'll see chapter succession form down here, and to request a new chapter if you have anybody who you know of who wants to create a student chapter at their university or in their area. Request the chapter chair succession form, click there. It's all very easy. You type your name and your email. And then you will just select your area, what chapter you belong to, who the current chapter chair is, their email, when they started. Oh, I think this is the new chapter chair actually. So as you're doing the succession form, this would be, for example, if we were rolling off Jenna and we were bringing in Lucas, Jenna would be the one submitting it. She would put her name in her email, or if Lucas were the one doing it, he'd put his name in his email. And now the current chair is Lucas. So it would be his area, his chapter. It would be his name, his email, and when he starts, which would be today, and then a chair-elect and a chair-elect email. It's really important to have that chair-elect so that you're not scrambling next spring when it's time to do the same thing. You know who's coming in. So, and then that anticipated date would be next spring or 2 years from now, depending on your situation in your area. And then if you've got a profile on JRCLS and you are a student chapter, that's all it takes to submit it. And that information will come to us. We'll be able to change that on the website. If you look at chapters and committees, you go to student chapters, any student chapter will have their chapter leadership down here at the bottom. We'll take care of all of that for you when you submit your chapter succession form. You'll have your name, your position, and you'll have the permissions to go on and add your board and send emails from your chapter. So we hope that you take the time to do that. And we look forward to thanking all our past chapter chairs that are rolling off, and then our new chapter chairs who will be rolling on. We hope to see your names rolling in soon. So thank you.
Thank you, Amy. I will be sure to fill out that form. All right, Amy Larson, we're ready for you.
Thank you so much. And it's great to be here with you. I'm grateful for those who could join us for the live meeting, as well as for the many who will be joining us later. Also want to give a big thanks to Jenna as well. Add my thanks to her and the board. It's been great to work with Jenna and for her vision and leadership. So we will miss you and wish you well. Also so excited to be working with Lucas, who will be coming on for this next year. So I've been asked today just to share a few thoughts about why the J. Reuben Clark Law Society has a part of its mission and vision statement is defending religious freedom and what we're doing to support that. So for any of those who are new to the organization, as well as for the rest of us who are needing a refresher, I just wanted to go over what our mission states and then the part of the vision statement that relates to religious freedom, which Tanner will be speaking to us more about in a few minutes. So the mission statement reads this: we affirm the strength brought to the law by a lawyer's personal religious convictions. We strive through public service and professional excellence to promote fairness and virtue founded upon the rule of law. So our vision says that as lawyers and law students of faith, we accomplish the mission of the Law Society in part by defending religious freedom and moral values. And we do this in collaboration with Law Society members, as well as other organizations and good people of faith. And so on this point of religious freedom, many of us are aware that it is almost a universally recognized as a fundamental human right, and is also widely considered to be an essential condition of human flourishing. And this is because it safeguards the rights of all humans to hold their own religious beliefs and to express them openly without fear of persecution or being denied citizen rights. Importantly, religious freedom also protects people's rights to live, speak, and act according to their beliefs peacefully and publicly. It allows us and all other people to be true to themselves at school, at work, in both private and public settings. And it also means that we shouldn't have to go against our core values and beliefs in order to conform with culture or government. So in these ways, religious freedom protects the whole of society and helps it to thrive. Thus, it benefits all people, whether they be religious believers or not. So because religious freedom is a basic fundamental right for human flourishing, it stands that the Law Society, people who are in a position of influence when making and enforcing laws and reviewing the legality of laws, we are in a position to defend religious freedom, and beyond that, should actually go forward in doing that. So when it comes to what the Law Society does to defend and support religious freedom and moral values, there are multitudes of ways we can do that. I just want to focus on a few that are some of the things that you may not know about, but we hope you'll become familiar with. One is that we have religious freedom lessons that are available online. If you go to JRCLS.org, like Amy Parker just showed, there's tabs across the top. One is called Religious Freedom. And under there, we have a committee that's there to support, but we also have under the resources tab some lessons. And one of those tabs that sends you to some religious freedom lessons. There's 6 different lessons that could be put together for a meeting with students in your law schools and also with attorneys to discuss the basics of religious freedom. You do not need, as a Law Society member, to become an expert in religious freedom to have a conversation about religious freedom and to say what it means to you. So you could do something as simple as a small group with other students, finding out what their beliefs are and talking about how your religion is important to you. Or you could do something much more formal in conjunction with other law students and people of faith to put those lessons together. Other thing that I want you to be aware of is on October 27th, we celebrate International Religious Freedom Day, and we can celebrate that in many ways. You can do something as simple as have a discussion with a family member or a friend about your religious beliefs or ask them about theirs. Or again, you can work with the local chapter or attorneys or other organizations of faith to discuss and celebrate religious freedom. Because if we truly believe it is a fundamental human right and it is fundamental to our flourishing, then we need to be actively promoting religious freedom in our lives. You don't have to do a lot of work, but we do need to speak up to talk about religious freedom. And you, as students of faith, have the ability to make a really important impact because of both your religious convictions and your legal training. So I would invite you, as you listen to Tanner's remarks and as you go forward to your legal studies and in your work, that you would make a point to consider why religious freedom is important to you, and then start a conversation with someone to share your beliefs and invite them to share theirs with you. So thank you for your attendance today, and again, your support of the Law Society. We're grateful for you and look forward to working with you. Thank you.
Thank you, Amy. It's wonderful to have such belief in us. I really hope that we can execute and live up to that. Let's turn to our keynote speaker, Tanner Bean. Lucas, will you give us his introduction, and then we'll just turn it right over to him.
Tanner Bean is an attorney at Fabian Vancock, a historic law firm in Salt Lake City, Utah. He focuses on employment, appellate, and religious liberty matters. In his work, he advises and litigates on behalf of small and large businesses regarding religious discrimination and accommodation, as well as religious individuals and organizations regarding their liberties. Tanner graduated with honors from Brigham Young University's J. Reuben Clark Law School. He received his bachelor's degree from Brigham Young University in English and joined Fabian Vancock after completing a clerkship at the Idaho Court of Appeals for the Honorable Molly J. Husky. Currently, Tanner serves as chair of his firm's Employment and Labor Practice Group. He also has chaired the Labor and Employment section of the Utah Bar. He currently serves as secretary and chair for students of the J. Reuben Clark Law Society's Religious Freedom Committee. He served as a founding chair and co-chair of the JRLS's Religious Liberty Fellowship Program for law students and recent graduates. Tanner frequently writes, presents, and trains others on topics such as employment law and religious freedom. Apart from his law practice, he balances his affinity for the outdoors with his love of ice cream. Tanner, thank you for joining us. We're excited to hear what you have to share.
Thank you, Lucas. And good to be with everyone. Good to see some familiar faces and some new ones as well. So today, you've invited me to talk to you a little bit about faith in the public square. And can we still speak our convictions in the public square? And it's an interesting topic. I like that topic because it comes at religious freedom from a perspective that's almost a non-law perspective. And it's a perspective that many people in your communities, your family members, your friends, people you don't know, will probably feel about religious freedom. And so these are some of the practical questions that people have, and a lot less of what is the precise, bent of the Supreme Court jurisprudence in this particular area of law, right? And that's important too. But practically, I think if you have a grasp in some of these topics that are likely to be those that you're going to be talking to other people about that are non-lawyers, or even those that are lawyers that are not specifically schooled in religious liberty, it's going to serve you really well in making those conversations that Amy just talked about. So I'd encourage you to think about that and what we talk about today, kind of in that mindset, how I can use this. So today I'm going to share my screen too. Let's see if we can get that going. And we're going to talk about two things in particular. First, I want to talk about, let's see here. Sorry, just taking me a second to get up. First, I want to talk about kind of what is the public square. And then I want to talk about what religious liberty protections are like, and then we'll just kind of meld them together at the end. Okay, is everyone seeing the screen? I'll take that as a yes.
Yes, we are.
Yes, awesome. Sorry, it blanks out me. So, okay, so two questions. Like I said, what is the public square? One. And then two, how do we protect religious liberty in this country? Legally, how is it protected? And how does that fit into the discussions about public square contributions? So we're going to look at a few pictures about what is the public square. And these might be things that you might think of first when you think of the public square. It also might be things that your friends, neighbors, strangers would think. So could it be conceived as political dialogue, contribution to a political dialogue, the public square being where you share your politics, or what should happen with this country, or what's moral, or what's not, right? Is that one conception of a public square? Certainly, I think for many it is, but is it the only one? Probably not. What about news media? is that the public square, and how things get talked about in a semi-official kind of media capacity? Is that what we conceive of the public square? Perhaps some people think that as well, like what's legitimate to say or inappropriate to say in those sorts of contexts. What about entertainment media? Is that the public square in how, topics of religion or other topics are treated in popular culture, and how those things are conveyed in movies or in television or in books or in other, podcasts, for example? Like, how are those things discussed? Like, is that the space where a public square discussion is happening? And maybe increasingly so these days than, 10 or 15 or even 20 years ago. What about protests? Is that the public square? Is that where it matters voices to be heard, in religious contexts or not? And does it matter where those protests happen? As we're seeing here in this picture, maybe, on a city street, or was it an approved protest by the government? Was it not? Does it matter where it happens elsewhere? For example, in a suburb, in someone's neighborhood, on the, entrance to the high school parking lot, do those things matter? And are those legitimate places to contribute to the public square? And when we are worried about our contributions to the public square, is this the venue? What about social media? Is social media the public square, right? Is it an unregulated space where we can all share opinions? And even if it's not unregulated, is that the most important space for there to be tolerance for religious dissenters or not, right? Certainly there's just a mass of information, and people share and contribute and go back and forth in different ways than they would in person. But it's all, relatively savable and permanent. And then also like political contributions, right? Is this the public square? Other than just like talking about politics with your friends or family or the community, is your reach and access to your representative in the, in Congress and state legislatures, in your municipal areas, right? Are those the most important places for public square contributions? Or are private spaces more important? For example, what about corporate spaces? We live our lives at work. A good chunk of our portions of lives are spent at work. I mean, if you think about how your day or your week is spent up, most of that time's at work, and the people you talk to at work, what sorts of contributions are appropriate there? What can you say? What can you live? What can you be in the corporate space that so many of us occupy for most of our lives? So those are some of the things that I think about when I come up with like venues or think about what public conceptions are of the public square. But another thing that I think about is when we're asking ourselves these questions, like, are we being wrongfully excluded from the public square? Or like, is the public square accepting to us? Another thought that I have had, and I'm sure others will think that are probably outside of the kind of the religious sphere, is that, are we really just being babies? Or are we trying to be the cool kids, right? Are we sad that we're not fitting in, right, to the public discourse or like the cultural mainstream of the day? Is that what's really the issue, right? Is our complaint just that we're out of fashion and we're feeling excluded because we're out of fashion, even if we truly have access to the public square? So that's something to think about. And I don't think in that way, right? But I think many that perceive kind of problems or perceive people that are raising problems about access to the public square might feel this way about those sorts of conversations and issues. Now, of course, there's a highly more legal way to think about the public square. And so here are some examples of some First Amendment forums. We're not going to talk about free speech and the ins and outs of all the case law, but just for you as law students, many of you who've probably taken First Amendment classes or something similar to that, your con law classes, you'll have been exposed to these concepts of different sorts of fora in government intervention. And the important thing here to look at and to think about legally when you're making these considerations is, what is the level of government involvement, right? What has the government authorized the space to be? Is it a traditional public forum where there is a lot of ability to share and express content even in a government space? Or is it a non-public forum where it is a government expression of space, but very, very limited? Or maybe it's one of the things in between. Maybe it's limited or designated to particular types of topics or issues or spaces. And so those are some things to think about when we're talking about legal forums, right? Not necessarily the ones that live on social media or in the news or in our, cultural, spaces like entertainment. But think about that and how that interacts with issues about whether we are really contributing to the public sphere properly or whether we can have access to it. Now, let's shift a little bit with that thinking about what a public forum is, what a public sphere is, and whether we can contribute to the public square in a meaningful way as religious people. And let's map onto that religious liberty and how the patchwork of protections throughout the country interacts to protect the religious free exercise of individuals and organizations, and see if that gives us another avenue, another window into what we can understand about how things operate. So this slide right here is going to do a lot of work, so we're going to stay here for a little bit. But it's a progression of the different categories of religious liberty protections that exist in our country. So I'm going to start up on the top, and FA stands for First Amendment. So this is our top level religious freedom protection document in the country. The federal constitution protects religious freedom in the First Amendment, of course. And leading up to the 1990s, strict scrutiny review of the First Amendment free exercise provision was required, meaning that if you were a religious individual or organization and the government burdened your religious freedom, regardless of whether it was intended or just incidental, then you as the government still had to pass strict scrutiny review in court under the First Amendment, meaning you had to indicate to the court that you, the government, had a highly compelling government interest that you were trying to advance by prohibiting this religious exercise. And in addition, you also had to show that you, the government, were using the least restrictive means to accomplish that really important government interest. Now, that's a very difficult burden to satisfy. And so it is very favorable to religious organizations and religious individuals. And so under that strict scrutiny framework, many religious freedom claims were successful. However, in 1990, in a case called Employment Division versus Smith, the Supreme Court modified its interpretation of the First Amendment. And it said the only intentional burdens on religious freedom got strict scrutiny review. And the way they said this was strict scrutiny review only is permitted for non-neutral or non-generally applicable laws. Non-neutral meaning that the intent of the law, even if it wasn't on the face of the law, but if it was behind it, if the intent of the law was to specifically target religious exercise, or whether the law is not generally applicable. There are exceptions that are allowed to secular groups or other instances that show it's not generally applicable, such that the government insisting upon no for religious exercise in this context is not reasonable because it permits that same sort of activity that hurts its government interest in another space. And in that way, you can think of it as kind of like an equal protection or fairness, situation. If the government's allowing something that hurts its government interest in one context, but says that it can't allow that same sort of exception in a religious context, it's really a religious discrimination issue, right? And if there's going to be religious discrimination, that is a good reason for strict scrutiny review to apply. Now, over the past few years, especially the past 5 and 10 years, the U.S. Supreme Court has been developing additional kind of ways to demonstrate a lack of neutrality or a lack of general applicability as to these sorts of claims, meaning that there are more practical ways for the court to apply strict scrutiny review than before. Many people have been capitalized upon these, and there have been a lot of big wins at the U.S. Supreme Court upon these bases. There's a lot of confusion about them still at lower courts, even just the lower federal appeals courts. And for that reason, and for other reasons, there have been many cases that where litigants have been asking the U.S. Supreme Court to reverse the entire scheme that they've had, this non-neutral, non-generally applicable laws scheme, and just return to a framework where every single religious freedom burden, whether incidental or intentional, merits strict scrutiny review. And there are several justices, I think up to 4 sitting justices currently, that have indicated that they want to do that, or they're willing to look at it and see if it can be replaced, that framework. That would be really big news for religious liberty, because it will make a lot of what I say next kind of irrelevant. So that's the First Amendment, right? So that's the federal government. And the First Amendment has been incorporated as to the states, so you can use it as a cause of action in any state or federal context. Now, Congress did not like this decision in 1990, this Employment Division versus Smith decision. And almost uniformly, I think with only 2 dissenting votes, Congress passed what's called the Religious Freedom Restoration Act at the federal level in 1993. And that applied to any burden on religious freedom, regardless of whether it was incidental, whether it was intentional, or whether it was made at the hands of state or local or federal government. However, in 1997, in a case called City of Bernie versus Flores, the Supreme Court said Congress did not actually have the authority to pass that act with the powers it used to make it applicable to state government actors. So they limited its application only to federal government actors, meaning that you now had this kind of weird system where you had to look at the First Amendment, and it wasn't very protective unless it was a non-neutral or non-generally applicable law. And then you had to go and look at the actor, the government actor, for federal RFRA. And if it was a federal actor, you could still use federal RFRA and make sure you got to that strict scrutiny review. That was really important. But if this was a religious freedom violation that came by the hands of a local or state government actor, you might be out of luck. You might only be able to use the First Amendment, and it might not be very helpful to you. So in the wake of that 1987 decision, many states passed their own versions of RFRA. Some people call these state RFRAs, some people call them mini RFRAs, but basically they are codifying the same federal RFRA scheme with some variations here and there into states, meaning that even if the religious freedom burden came by the hands of municipal or state government actors, you could still have a path to that strict scrutiny review, which is really important. And states have been passing these acts and have continued to do so since 1997, even as recently as just the last year, a few years ago, such that we now have a Religious Freedom Restoration Act at the state level in 29 different states. However, you can imagine how that adds another layer of this patchwork protection. And we'll look at a map in a minute, and I'll show you what this looks like visually. But now you have to ask a lot of questions when you are trying to bring a religious freedom claim. You have to ask, well, is the First Amendment really helpful to me? Or is it only applying a lower level of review? And, was this a government actor, a federal government actor? And if so, I could use the Federal Religious Freedom Restoration Act. But if it was not, now I have to look to see if my state, the state at issue, has a state level Religious Freedom Restoration Act for a state or government, local government burden that was imposed upon me. And if you don't have any of those things, you might only be left with an unhelpful First Amendment scheme to getting protection. Now we're going to add on another layer, if you can imagine, which is state constitutional protections. Now the states, of course, have all of their own constitutions. Many of them have very good protections for the free exercise of religion that sound almost identical to the First Amendment. Some are read differently. But even in states where they read identically to the First Amendment to the US Constitution, those state courts of highest resort have interpreted the state constitution to merit strict scrutiny review to all claims of religious freedom, whether the burden came by incidental or intentional means. And when you map those and kind of layer those on top of the states that all have a state RFRA, you get 36 states that have strict scrutiny review protection. However, I've listed the states right here that if you happen to live in one of these states, you might be out of luck as to that, and you might be stuck only with religious freedom protections afforded by the First Amendment, which we've said is lower, right? Now, there are many, many other layers we could put on top of this. This is the most general, but the very bottom point here is other statutes. Congress did try to fix this problem created by the 1997 decision, the City of Bernie decision, which invalidated the federal RFRA as to state issues by passing the Religious Land Use and Institutionalized Persons Act. And they passed that with a different power, meaning that it was applicable to the states, But by then, the consensus that had existed with the federal RFRA in 1993 had fallen apart in such a way that they could only pass it as to two limited topics, which is land use issues, like zoning restrictions, where you can buy land for a church, where you can have a church service, etc. And then institutionalized persons, folks that are in prison that have limited rights, but don't give up all of their religious liberty rights. So things like dietary needs, maybe having a specific beard, or maybe like a piercing of some kind, that is a religious-based requirement. So we have those issues. Interestingly enough, a lot of states have adopted their own versions of those as well. And other statutes protects religious liberty in other contexts when it's not just government actors that are having problems. So Title VII, that is the federal employment non-discrimination statute, for example, and it prohibits religious discrimination and also requires religious accommodation in the workplace. And then there are a variety of other exemptions and laws of all sorts, federal and state, municipal, that extend to things like taxes, housing, education. Really, if you should look into it, if you're ever advising a religious individual or organization and you think, oh, well, this is the general rule, don't always take that for granted. You should kind of ferret out whether any religious exemptions apply, because religious institutions tend to be treated differently because of this concept that they are kind of a separate sphere of authority, and that the courts and the government should not step into that sphere of authority. So that is this big slide that we're going to go through today that really talks about how religious freedom is set up in our country. So we're going to move on now to look at these maps. So this first map is a map, and I stole this from the Beckett Fund for Religious Liberty, so give all credit to them for this map. But this map is in the blue areas, indicating where state religious freedom restoration acts have been enacted. And like I said, these things are in flux. If you are in an area of the country that is gray here, consider bringing it up with one of your representatives. State RFRAs have been kind of in and out of political dialogue about being good or bad. 5-10 years ago, you probably heard them as being pitted, directly against LGBTQ rights. I think wrongly so, but I think that's kind of shed a little bit. But states that you would expect to have them, like the state of Utah, my home state, didn't have a state RFRA until 2025, if you can imagine that. And others have been passed in the Midwest in 2025 and since then as well. But they are really fantastic for protecting religious minorities. And so if you're interested in trying to make some headway with your legislators, I would say that's a great narrative to build, as Religious Freedom Restoration Acts as a protector of minority religious rights. And that has a lot of narrative purchase. Now we're going to look at another map now. And this is the map of state RFRAs and those states whose constitutions have been interpreted in a way that provides strict scrutiny protection. So you can see there are a few more. Washington State, added up here for those West Coasters on the call. But there are some still gaps. But a lot of the country has strict scrutiny review. However, some of these states are the most populous states in the country, which still do lack those protections, which for a lot of people practically means a denial of religious freedom. Okay, we're going to switch a little bit now. That was a lot of the legal and how our religious free exercise protected in this country, how that might factor in to our contributions to the public square. And I want to recommend a book to you. This book, as you can see, is called The Right to Be Wrong. It's not a long book. If I were to hold up my fingers, it'd probably be, I don't know, probably ½ inch, maybe, 3/4 inch deep. So it's not your textbook size by any means, but it is a really good discussion about religious liberty in America. And I love its title. It's called The Right to Be Wrong, and how that is, emblematic of how religious liberty operates in our country. Another book that I recommend to you that's even more narrative-based is called Deep Convictions by Steve Collis. It's a fantastic book, and it goes through, I think, 3 or 4 kind of narratives about individuals and their journey through the religious liberty in our country. Both highly recommend. But religious freedom really is the right to be wrong. And I think we can judge the health of religious liberty and the rule of law over religious free exercise in our country by the practical permissions that we give to religious dissenters in the public square. So even when there is broad cultural agreement on one topic, if judges and legislatures and organizations are able to still protect dissent over that topic, even if it's diametrically opposed, and those people who are the dissenters can still participate in our society on equal footing, that is when we know the public square is operating correctly, and that when religious individuals and organizations have access to it and their contributions are being heard. Now, that doesn't mean that religious dissenters are going to persuade everyone in the public square. I think that's important to note, especially as dissenting voices or minorities, their view is not going to be the view of many people. So even if it's being tolerated, being heard, that doesn't mean it will be adopted. The right is one to be wrong, right? Now, I'm going to show us some examples of some recent kind of religious dissenters and how those have been handled by the U.S. Supreme Court. And maybe these are good examples of religious dissenters being tolerated, maybe not. But this first picture is a picture of Sharonell Fulton, and I believe her foster family. She may have adopted some of these children. I don't remember precisely the facts of that, but she was the named plaintiff in the Fulton versus City of Philadelphia case from a few years back from the U.S. Supreme Court. And she's a good example of a religious dissenter. At the time, and this may have changed a little bit since then, but by and large, the cultural consensus is that raising children in same-sex households is not an issue, right? And that should be accepted on the same basis as raising children in, heterosexual marriages or anything like that. Anything that might be termed traditional marriage for some people is what they'd like to use as a term. But that was not her persuasion. Her persuasion is that she needed to have children raised in a home where there was a mother and a father, and that was the correct thing. Same-sex, was not correct. The city of Philadelphia was a proponent of the more culturally mainstream view, which is that, if you were going to come and participate in our foster care and adoption programs, you need to participate on an equal basis, and you need to affirm our non-discrimination rules, which require that adoptive and foster care parents, will be certain ways, or if their children are of certain persuasions in terms of sex or gender identity, that certain acts be taken, basically had to agree to those rules. And of course, at issue is not only, these parents who are trying to adopt in that system, but also the adoption care providers, like Czech Catholic, social services, for example, adoptive services, and those organizations that want to participate and facilitate adoptions and foster care with the government because it's so needed. There's so many children that need those services, but can't affirm certain non-discrimination rules on the basis of sexual orientation or gender identity because of their religious beliefs. So that's an example of one of those clashes. Now, this clash was resolved by one of those exceptions to the First Amendment strict scrutiny requirement, which was that the law was not generally applicable. And what the Supreme Court found in this particular case is that the ordinance at issue, which required adherence to the non-discrimination rules, which protected on the basis of sexual orientation and gender identity, there was basically a big carve-out, which gave discretion to the kind of ordinance enforcers, if you will, to say, oh yes, but despite the rules to the contrary, in this case, we're going to provide an exception. What was interesting is that the Supreme Court said that there was no intent to provide an exception here or elsewhere, and in fact, never had been used that exception to provide exceptions, but the mere presence of it in the statute was enough to indicate that it was not generally applicable ordinance government action, so that strict scrutiny review was merited, and the burdens that were placed here were not legitimate. Now, one unfortunate consequence is that many, many children, which were in dire need of homes, were not able to receive them during the period of litigation, and even after the effects have been really strong. So although there was ultimate mitigation, this religious dissenter had a lot of, really unfortunate circumstances that they had to navigate afterwards and during the lawsuit. So that's one example. But, for many, it's a win because it vindicated a religious dissenter's right to hold an opinion that is contrary to the mainstream, that some people think is damaging and even dangerous, and yet was still protected. And so going forward, that serves as an indication culturally to religious dissenters that happen to be, have traditional marriage or traditional gender identity values, that they can speak and participate in the public square, interact with government, and still be part of our country on equal footing. So we're going to go back to this next picture, or go forward to this next picture. And this picture is of a man brewing ayahuasca tea. And this picture helps us remember the O Centro Espírita do União de Vegetal case, which is short for UDV, is what I like to say, much easier to say that. But this is another example where the Supreme Court vindicated the right of religious dissenters, especially where people thought their practices were dangerous and problematic. And this happened in the Religious Freedom Restoration Act context, not the First Amendment context, the Federal Religious Freedom Restoration Act context. It was a small religious group that said ayahuasca tea was necessary for them to kind of commune with the divine, to particular in their rituals, sacramental practices, what have you. But of course, ayahuasca tea and other substances like it are prohibited, their usage, under the Controlled Substances Act at the federal level, as certain scheduled substances that have been indicated by Congress that they have no acceptable use or medical use or beneficial use, and in fact are dangerous to society. So we need to restrict them and criminalize their usage even. So this group sought protection through the Religious Freedom Restoration Act, and ultimately the Supreme Court said, yes, the government does have an interest in protecting public health, public safety from drugs. Of course, those are important interests, but there are less restrictive means that you can use here to let this religious organization do its thing and still protect those interests, right? And you can think of all sorts of reasons and ways to do that. They might have, some requirements in the religion to communicate with the government more frequently, to tell them where they might be doing their sacramental services, to have a clear understanding of the quality or the source of some of their sacramental material, et cetera, et cetera. Or if it's being imported, to talk about importation techniques and other things the DEA uses, or maybe to compare them to more like prescription medicines and how those are handled. So there are lots of different options to do that. But ultimately, the Supreme Court did affirm the right for this religious organization to use ayahuasca tea, despite the criminal prohibitions that exist in the law, despite maybe the cultural values, kind of like the war on drugs mindset, and how this is really problematic for the community and for people, and setting bad precedent that maybe religious liberty stands for drug use or something like that, right? So another example of a religious dissenter protected. And I happen to know that this religious organization is still alive and well. They've grown, I think, maybe fourfold since their Supreme Court days, from about 100 members to 400 or so members. But still just a really small group in the comparison to the larger community. But they can make contributions to the public square. They can go to work. They can go to Home Depot to get their tools. They can interchange with the government and not fear retribution. They can participate in public despite their religious objections. So both of those, Fulton and O Centro cases, both positive examples of protected dissenters. And here's my last slide, which I'll show you, which is one that's not quite as positive for the religious organization. This is a picture of Oak Flat, or what Oak Flat may soon look like. And if, for those of you who haven't heard, Oak Flat is a case that went up to the Supreme Court recently, most recently decided of these three cases we're talking about today, where Native Americans had a really strong religious belief in connection with the land in which was their ancestral land. In short, basically, that the deity of their people was connected to this land. Now, they made a lot of different religious claims, including those under the Religious Freedom Restoration Act. But ultimately, what was at issue is whether a private organization could come in and mine the land in such a way that it would basically become unusable. What they claimed, and which may be in fact happening, is that these mining companies were going to undermine under the ground in such a way and so extensively that eventually the entire radius of a mile or so perhaps would just fully collapse into the ground, kind of desecrating their entire property, their ability to worship the deity that they believe lives and resides and is connected to the land. Where a lot of these folks have kind of these important rights that they contribute. They pull sacred plants off the specific area. Anyway, it went up to the United States Supreme Court, and there were a lot of technicalities here because it involved Native American rights and land rights. and usages, and Congress had passed an act basically permitting some of this mining to occur. And ultimately, over some pretty vigorous dissent, including one by Justice Gorsuch, which basically accused the rest of the court of treating religious minorities, especially Native American religious minorities, differently from those other religious minorities or majorities that had come before the court in religious freedom cases. The court did not grant the Religious Freedom Restoration Act or other claims in this case on behalf of the Native Americans. And there are some other fights that are continuing to go on there, but that's an example where there's a pretty significant religious dissenting voice, pretty unusual one from some people's mainstream standards, right? Whether secular or like a Christian mainstream viewpoint of religion about a deity being connected to land. For some people, for some other people, that might be very obvious and implicated, but not so much that our structures and systems of government were able to protect that religious dissenter. So on the bad example, let's pivot to how we can make an impact with religious liberty. And the question I want to pose to you here is, how can I protect religious dissenters? I actually think that's the most important question, or one of the most important questions to ask here when we're talking about contribution and protection of the public square for religious individuals and organizations. Because religious liberty is about the ability to protect those religious dissenters and incorporate them into our society so that we can still live together with our differences. And those differences are really big, right? They're existential. They're as big and most as important as whether you have been saved, for example, a question about that, or whether you're achieving eternal salvation. Big questions, right? A lot at stake there on those questions. But if we can find a way to live together with those significant existential differences, that will help out significantly, not only in the area of religious freedom, but also just culturally, with our civility issues, like the questions that we're debating today about maybe, immigration or taxes or even war, right? Some of those pale in comparison to the question of my eternal soul and where it's going to go, right? But if we can figure that out, surely we have some offset benefits for civility in other parts of our country. So how can you protect religious dissenters? I would posit that you can make just as much, if not more, impact for religious freedom in your social and pro-social behaviors as you might in any legal action that you can bring to protect religious freedom as an attorney. But as an attorney, you have a special eye, you have a special understanding when you go into lay conversations or with people that will help you guide them. So I would suggest, for example, that when you hear criticism of others' religion, and from someone else, maybe you're at a park, someone's saying, "Oh wow, those folks over there, that's ridiculous, the way they do things, blah blah blah," right? When you hear something that sounds very othering or like dehumanizing in that respect, that they're trying to make someone feel less than because of their religious beliefs, I would challenge that in conversation. And you can do it, calmly. It doesn't have to be a hostile thing, but you could say, "Yeah, I also agree that their religious beliefs, they're not for me. That's not what I believe. That's not my path to God. That's not my path to truth. I don't think that's right." And you could even say it's, in some situations, that seems problematic, right? But you should pair that together with another statement, something like, "But they do seem really sincere. I don't think they're doing this for malicious purposes. I think that's truly what they believe. And they have a right to believe something just as much as I have the right to believe what I do." And that's what the First Amendment is all about, right? If the First Amendment doesn't operate as a neutral principle, or the Religious Freedom Restoration Act, or the many statutes that we've passed that protect religious freedom, if those don't operate on a neutral basis, they're not really protecting people's right to exist on equal footing in society. They're just protecting established rights, or well-known rights, or religious organizations or traditions. It doesn't do so well for principle. And there's a lot that can happen over Thanksgiving dinner or in the park or at work where someone makes comments like that and you say, "Yeah, I agree. But actually, I think it's not a huge issue because they're going to do what they're going to do. I'm going to do what I'm going to do. I'm going to still pursue my path to God. And I'm glad that they have the ability to do that too, because that means that I can as well, right?" And the same is true of contribution to the public square, right? If those people can contribute to the public square, get up in, news media setting, have a positive, portrayal in the next blockbuster movie or something like that, even if you disagree with them, it's a benefit for all of us. For many of us on this call that belong to the Church of Jesus Christ of Latter-day Saints, we are religious minorities. We have viewpoints that many think are strange, odd, and even dangerous. And so protecting others who have religious dissent is really important, even if you're just operating in a selfish basis for protecting religious freedom for yourself. It's really important to protect other people. Now, other than just conversationally, you can, of course, learn more about religious freedom principles like we're doing today. Having that framework of understanding helps you be able to talk to people and say, well, actually, here's the real issue. We need to protect this rule. And if we don't let these people do this, then we will lose our protections ourselves. And learning how those neutral principles can operate. And then I would say, once you've done that work and once you've done that thinking, even if it's not fully formed, it's just budding, you are in a better position than just about anyone to go into your communities and when issues pop up, to address them. Now, that might happen at a school board meeting or some community space. It might happen at work, and in fact can happen in the public square, no matter how we characterize that term or understand it, whether it be social media or to protest, what have you, right? You will be poised to make those comments and to protect religious dissenters. And I would really encourage you to do that. And with that, we're going to wrap up this portion. I'm excited to have some questions, maybe some answers from you about faith in the public square, and to hear how you've engaged and look to engage forward. Thanks.
Wonderful. Thank you so much, Tanner. So we have a couple of questions that were previously sent in that we'll ask you. If there's anybody here that has a question that they want to ask, you can put it in the chat and we'll see how much time we have to get to the questions. But our first question kind of goes along with the Fulton case that you talked about a little bit. It said, in the context of adoption, religious belief and public policy often clash over the interests of children. How can we speak out effectively to communicate our own religious beliefs in such a sensitive area?
It's a great question. And it is a really sensitive area, right? Because we're not only just talking about differences between policy and preference over whether, certain rules like non-discrimination rules should be imposed in these contexts, but we're also talking about children, right? We're talking about protecting children, the most vulnerable people, those who do not have homes, right? And so you can see how it's very persuasive to argue the non-discrimination side of things, to say, no, anyone that participates in our adoption or foster care space, they need to accept all children, and they need to accept them in all contexts, right? And with these certain non-discrimination rules we have imposed in our system. And we're doing that so that we can get as many children adopted and into foster care as possible. However, you can use that same sort of supply problem issue on the religious side as well. If you are excluding religious providers from an adoption or foster care system who do fantastic work and reach probably a target population that the government might not otherwise have reach into, right? Folks that are really willing, really charitable, right? You're going to lose a massive segment of society that's willing to contribute to a foster or adoption care program. So I would like to, my position on that topic is that you really need to increase access in any circumstance, right? And foster and adoption care agencies that contract with the state are interesting because a lot of them do provide kind of unique services. Some focus in cultural spaces. So for example, Native American adoption or, African American adoption. And, there are lots of interesting things about this area where, you can even, make preferences as, adoptive parents and, folks that might be ethnically related to you. So you have an appearance of a family visually. Some people don't think that's important. Some people do. But I would say increased access is the most important thing because the kids are the most important priority. And we can work out at an administrative level our differences on religious liberty issues. And I think what the Fulton case showed us is that if there is any play in the joints with exemptions, or whether we're giving folks exemptions on the secular side for one reason, there shouldn't be a good reason why we can't give them on the religious side either. And another thing I'll say that is kind of interesting in the development of some of our free or establishment case law, no establishment of religion case law, is that the government has been more and more willing, or I should say the Supreme Court has been more and more willing to kind of provide this principle about if you're going to send out money from the government to programs, and then people are going to come and government partner with the government or take use of those funds, that they have to be provided on an equal basis. So that might be another way to think about it. Like, well, if we're giving money to, like, let's say that there's an LGBTQ specific adoption and foster care agency. If we're giving money to them to do their thing that's specific and unique, there shouldn't be any reason why we can't give the same sorts of monies to, Catholic adoption and social services, right? Why can't they do something specific and unique? So not to say there are unresolved issues there, because there are, right? Still issues, but there are lots of creative ways to think about that, and maybe even restructuring how we do administrative benefits and award contracts to adoption and foster care agencies is something to think about.
Okay, wonderful. Thank you. Our next question is, in criminal proceedings where a religious institution appears as a witness, for example, regarding offenses where a victim alleges sexual abuse, or as a defendant, for example, for concealment or failure to report, how does the law protect religious leaders for upholding their clerical privilege?
Yeah, this isn't something that's super squarely within my expertise, but I will tell you that those protections do exist for important reasons. There were some foundational cases where it was challenged that, basically a Catholic priest had to confess everything that was sent to him in confession, right? And ultimately the law upheld that that was not going to be permitted. But there are lots of backs and forths on that issue. There's a lot of nuance as to it, because again, we have this kind of protection issue, right? We have this, especially child protection issue, and we want to make sure those are really important. But those privileges do exist, right? The clergy penitent privilege does exist. It applies in lots of contexts, and it is often a protection both for the individual confessing as well as the individual confessed to, whatever clergy role or title that they might have. And that is, I think it's important to emphasize just kind of the undergirding principle and why that privilege developed was that because of the First Amendment and the conception of the framers, they really did view religion as a separate sphere of authority and government even, right? And so the First Amendment is phrased in such a way that says, we're not going to intrude upon that sphere. Congress is not permitted to do that, right? And by extension, local and state governments are not permitted to go into that sphere. So that kind of goes to that topic. Probably not the best one to answer that question for you, but that is some of the reason about why we have those protections. But there's nuance and, of course, really important interest in protection.
Okay. I'm going to ask one of our questions that we have in the chat now, which is in terms of like undocumented immigrant, illegal aliens, and religious freedom, how do churches protect these individuals' freedom while also upholding current law? For example, what if a group of such individuals entered a congregation where a police officer or other federal officer goes and whom no such individuals are subject to certain laws? What is the federal officer's duty in this regard where there's conflicting duties against constitutional rights and federal duties?
Yeah, this is an area of law that's in movement, I know. And again, I'm certainly not the expert in immigration matters, but I know historically there had been some regulatory guidance for like Department of Homeland Security, which indicated that there were certain safe spaces, and churches would be among those, right? Where authorities could not come in, they could not, seize individuals, start deportation proceedings. And there are efforts right now, to push to Congress, I think something called like the Safe Space Act or something like that, where they're hoping to codify those safe spaces. But right now it seems to be an issue of regulatory decision. I believe the Trump administration has made indications that it has kind of removed that from the regulatory guidance. And so that's prompted a lot of folks' concern. And it kind of goes back to the separate spheres concept again, right? Does the government have authority inside of a church to kind of intrude and seize congregants? I mean, that sounds so dramatic. And if you can imagine happening that in one of your congregations, it'd be really problematic. And it's also decreased religious communities and their ability to feel safe in their safe spaces. I know in Salt Lake City, after the aftermath of some of these large kind of immigration, raids and efforts, the immigrant population attendance at soccer meetings plummeted, for example. And that may be true just as well in other congregations across countries, depending where you live, whether you feel safe in your space or not. But I certainly would like to see an act like that passed so that we can feel safe in our contribution and our public engagement. I wouldn't say that, inside of a church building is a public square, but certainly it should be a safe space, really closely guarded by religion. So I would like to see some development in that area. But I don't think there's anything particularly in the regulations that I have heard about of recent, days that would indicate that.
Okay. Our next question. If you live in a state that does not have a RFRA, how do you recommend approaching legislators? Do you have suggestions or strategies to successfully start this conversation to get something going?
That's a great question. I kind of hinted this earlier, but I think a great way to do it is talking about a really good narrative. Narratives do way more work than you think they do, especially in law school where you're learning about the doctrines and the ins and the outs of like how these things interact with statutes and the regulations, how to find them and like fine tune the wording of something. Narratives do tons of work at the legislatures, especially as you get down to local spaces. So I think start there. If you can identify a story in your community and state where you say, look, these people are really sincere, they're really fantastic, but they're getting locked out of protections, or at the very least, they are very uncertain. They can't engage in the public square or just in community like we do, because I feel very confident in my, religious freedom being protected. But I know that because I'm from a mainstream religion group or something like that, or I already have certain protections in law, or my religious beliefs are not some that means that I'm going to need the Religious Freedom Restoration Act or something like that. Those stories do a lot of work. And that's how the Utah Religious Freedom Restoration Act came to be. I was one of the kind of stakeholders that was consulting on the bill, which was an exciting thing to be a part of. And that was a real concern, talking about the real people. And I think what made the most difference, because it ended up being passed unanimously, including every Democratic, vote that's in the Utah legislature. And I think the Minority Religious Freedom Framework did a lot of work there, because those people felt like, yeah, sure, it will protect, the LDS people or the Catholics or the evangelicals if they need it, but they probably won't because they have a lot of protections already. But it will protect the Native Americans. It will protect the Muslims. It will protect, the Hindu, populations among us that have needs that we cannot anticipate. And as legislatures, we just don't prioritize practically because there is such a small segment of the population. But RFRA will give those folks the ability to make their cases to court in a proper way. It will allow that to happen. And that's what we're seeing under Utah's new RFRA is, some very niche groups making petitions to the legislature and the courts and even administrative spaces through the Utah RFRA. So I'd say start there, find a really good story, explain why it's important. And then last, I'd say be ready for the counter story, which is that Religious Freedom Restoration Acts exist as a sort of discrimination to stamp on LGBTQ rights. And that narrative is born out of this idea that the Religious Freedom Restoration Act will create exemptions from non-discrimination rules. And I will say that is possible because RFRA, just as the First Amendment does, it operates as like an exemption creating framework. That's how it works. So it can create an exemption, but those exemptions are like pinpoint, like little tiny exceptions for the particular people that brought the case. It's not broad-based. If some other religious organization wants the same thing, they probably have to seek it in law if the government wasn't persuaded by a different case. And so those exceptions are really small, so it still upholds the non-discrimination rules that are important. Like I personally want, my lesbian neighbors to be able to go to Home Depot without problem, or get an apartment, or get a job. Like that is not an issue for me, right? So I'm not worried that if RFRA grants a pinpoint size exemption to a congregation of even 500 people, that will have a significant impact, significant enough impact to stop my neighbors from being able to get the things they need on equal footing with everyone else. So that's what I'm saying. Narratives, all about narratives.
Great. Thank you so much, Tanner. We are out of time for questions, but you were so helpful and gave us so much to think about. And we'll turn the time back over to Jenna.
Thank you.
Let's do a silent round of applause for Tanner. That was really wonderful. You gave us a lot to think about. I'll just take a moment to give just my thoughts. This is the final time that I'll address you as the chair. So I am just so grateful to all of my board members. They have been such a support and such a help, as well as to the leadership of the society. They have taught me a lot and let me be part of a lot. And I hope that it goes on strongly and with joy. I just wanted to say that graduating from law school, I take a lot of peace in the fact that I'll be able to incorporate my values and my beliefs as a practicing lawyer, and that I really hope that I can go forward to extend that to other people as well. I believe strongly in that, and I'm grateful for the society that has cultivated that and that helps protect that for other people. So I hope that we all can become lawyers who believe and who defend those beliefs and who go forth to serve other people as well. So thank you again. Lucas, do you want to say a couple words?
Yeah, just thank you, Jenna, for leading our board this last year. I just want to highlight your efforts, to support students by assisting with creating new chapters. I was CC'd on a ton of emails that you worked on throughout the year. Training leaders, engagement through outreach to chapters, and creating a LinkedIn student chapters page and a newsletter. So thank you, Jenna. Also, I'm thrilled to, be working with Amy Parker. Students will greatly benefit, from the dedicated support, resources, and continuity that she's already bringing in this new position. So, this coming year, our student board is going to work to streamline processes and empower chapters and produce thought leadership resources. So lastly, just thank you to all student members of the J. Reuben Clark Law Society. Your activity and service in your chapters really helps people and elevates important discussions around our most basic needs and rights. So I'm looking forward to this next year.
All right. I will turn it back to Lucas again to give our closing prayer, and after that we will officially end our summit. Thank you again for attending.
Dear Heavenly Father, thank Thee that we could gather together virtually for the J. Reuben Clark Law Society's second annual Global Student Summit. Thank Thee for the work of Jenna and the board members and staff and leadership of the society for putting this together. Thank Thee for Tanner and his preparation and the important work that he does. Thank Thee for the inspiration and spirit that we felt today. Please help us in our efforts to defend religious freedom and help others, that we can be guided to those opportunities and know what to say and how to support. Father, we love Thee and we pray in the name of Jesus Christ. Amen.